You're all very welcome here this afternoon to this seminar on the Personal Insolvency Act 2012, which is co-hosted by Stubbs Gazette and Eames Solicitors. We have a very long association, over 25 years, with previously Dun & Bradstreet and now Stubbs Gazette. And we have a very interesting array of speakers for you this afternoon. Sorry, the gender balance isn't as good as it could be, but we promise to work on it for the next occasion. So, speakers this afternoon, and if you would permit me just to run through that, and also some of the sequencing around coffee and questions and answers. First of all, my name is Aidan Eames. I'm the managing partner of Eames Solicitors. I'll speak for 10 or 15 minutes in terms of setting the scene and some of the points that will be picked up also by the subsequent speakers. Joseph Shannon, who's the Director of Training in Compliance Ireland, will speak. And Joseph is a barrister, an experienced barrister from the Law Library and the Four Courts. And Compliance Ireland, as you know, are the leading regulatory and training body in the area of compliance, particularly around banking and financial laws and regulation. So Joseph then will be followed by Alan Bennett, and Alan is an Englishman. He's a partner in Ashford Solicitors, and he is responsible for their insolvency and reconstruction departments. They're also members of ADVOC, which is a network of law firms worldwide that we are connected with. And Alan will have some particularly interesting things to say about cross-border insolvency and so-called bankruptcy tourism and the options that are still available to debtors in Ireland and elsewhere. So that then will be followed by a coffee break at 3:10 for about 15 minutes or so, and we'll have the coffee outside and to the left. You pass by it on the door at the entrance as you arrived. So it's about 3 minutes down the corridor. But we're very keen that everybody would be back, if possible, for 3:30 with a fairly full agenda. So after the break then, Angus or Gus Garrity from Stubbs Gazette will speak about the Stubbs service, which is both credit reporting, tracing, analysis and collections, and will also speak to their new insolvency platform for personal insolvency practitioners, very document heavy and process heavy procedure, and their new innovation PIPEX. So Gus will speak to us on that. Followed then by a very interesting presentation from Michael, or Aiden, whom you know very well, is a very experienced insolvency practitioner here in Dublin. He's a partner in Kavanagh Fennell. We first became associated with Kavanagh Fennell maybe 15, 20 years ago. And they stayed with insolvency and reorganisation when it was not fashionable over a period there of 10 years. And they have built their business up to be the preeminent firm in this area. And Michael has a lot of experience, and will talk us through some case examples, the before and after, what can happen under the new regime, what potential outcomes are there. And I think this will be of interest to everybody. Needing no introduction then is David Hall, who is a businessman and a leading advocate for debtors and the entire insolvency regime and challenge faced by debtors in particular. And David, no doubt, as is his custom, will have a thought-provoking and stimulating contribution to make. That then will be followed by questions and answers at 4:40, leading on to 5 o'clock or so. If we have time within the presentation periods, we may take some questions, but otherwise we will take the questions towards the end. So that sets out a fairly full programme, and you're all very welcome this afternoon. I'm also bound to say that the fire entrance and escape is directly behind you. It's sufficiently close and sufficiently wide to go left or right if any such emergency would arise. Also, there's a questionnaire that will be distributed towards the end for feedback, which is very useful to us who pulled together the seminar. So, I've dealt with all of that. So to set the scene, as it were. Nobody in this room needs reminding that we have faced into and are still in the midst of a perfect storm in terms of personal debt and insolvency. It's been well rehearsed, the collapse of Irish banking and everything that has led to. Some 63 billion euros has been invested in the Irish banking sector by us, the taxpayers, since 2009. I think my biography on the run into this had me down as a director of Irish Bank Resolution Corporation, which was correct until the 7th of February, when on my birthday I discovered that in fact I was now the former director of the former IBRC. So everything changes, and it has given a new impetus now in the context of the loans and assets of that bank, the former Anglo and the former Nationwide, heading for NAMA via a special liquidation, and the challenges and opportunities that presents. So we've seen property values collapse across all classes with a write-down or revaluations of up to 60%, particularly in the residential market. Daft.ie has that at a 52% off-peak drop in the value of properties. Against that, we have 90 days plus in arrears on the residential side for 11% plus of mortgage holders, and 20% plus on the so-called RIPs, or residential investment properties, also in arrears for more than 90 days. And to cap it all then, we have unemployment running at 14.5%, or 400,000 people in this country. Side by side with that, as if this wasn't enough, we have escalating consumer debt, credit unions, banks, credit cards, unpaid utilities, fuel poverty, tax bills, you name it. According to Stubbs, in one of their more recent surveys, from their own experience and publications of judgments and demands that come into them, they see personal debt increasing fourfold to 10,000 euros per person that they deal with. And unfortunately, in my own native county of Sligo, that's up 15 times to 20,000 euros per debtor, dealt with by Stubbs Gazette. So, out of that, what happens? Well, we've been in a holding pattern to some extent since 2009, while the banks and the advisors have wrestled with this situation, and various interim solutions initiated by the banks, the lenders and the central bank have been initiated. So we have the so-called mortgage arrears process driven by the central bank and implemented by the banks in consultation, with varying degrees of success, I should say. Backstopped by a 12-month moratorium on repossessions of private dwelling homes, and various other short-term solutions being interest-only repayments, deferrals, interest holidays, and various short-term forbearance. Bringing us more or less up to the present tense and the outcomes of the Keane report and the Cooney Group report, leading to solutions which are settling in to some extent, some more successful than others, some being implemented in full and in part. The split mortgages, the warehousing of the unaffordable end of the mortgage to let process, the non-mark as in the residential investment properties, restructuring of loans, trading downs, various consensual workouts with the lenders, and repossessions and voluntary surrenders waiting over there on the side. All of this leading to the Personal Insolvency Act, which, depending on who you listen to, is either going to be the panacea for some of these issues and their resolution, or is going to be another one of these cans or footballs kicked down the road, depending on the level of engagement by the lenders in particular. So, the challenge now is a more balanced approach to unsustainable debt, and that the lenders and the borrowers can have a common understanding of what it means by can't pay or won't pay. And in the middle of this, we know that there are so many hard cases. We know them through our family members, we know them through our neighbourhoods and communities, through our clients as professional advisors, through our friends and through our families. So to differentiate between the can't pay and the won't pay is going to be a big challenge here. And there are also opportunists here who will see this new regime unfolding as an opportunity to get a further advantage, maybe that wouldn't otherwise be available to them. So, in the middle of the sequence of all of this legislation and new solutions that are being premised, we have the Personal Insolvency Act, which, as it were, replaces and supplants the 1988 Bankruptcy Act, which was 20 years in play with many imperfections and a very, very modest take-up. When we talk about the numbers of insolvencies, the numbers of the uptake, the Minister on the 21st of November 2011, Minister Shatter, said that he expected that against the backdrop of the number of bankruptcies that you could count on two hands over the last 20 years, each year for the last 20 years, if even that, he anticipates that there will be 3,000 bankruptcies arising under the new Act. He anticipates that under the two more robust schemes, that there will be up to 15,000 personal insolvency arrangements and debt settlement arrangements, that there will be up to 3,000 debt relief certificates, and for that he has taken the interim step of appointing 8 specialist judges of the Circuit Court who are the current registrars for the moment at least, until they embark on a more permanent or enduring solution to meet what, on the face of it, could be a tsunami of work in this area, certainly compared to what we've had in the past. So this new Act replaces the 1988 Act, which was 20 years in operation, but it was also 20 years in the making from the original publication of the Heads of Bill for the 1988 Act. That in turn supplanted the 1872 Act, which was 140 years in existence and operation. And again, in this new dawn, this new situation, we have the Companies Act, which is the New Companies Bill, rather, which is a consolidation of the Companies Acts from 1963 onwards, and with some interesting new features that relate to insolvency, including the prospect of examinership in the Circuit Court, and also a mooted solution that we understand will be discussed at the various committee stages of informal schemes of arrangement and enhancing the current procedures. So, in this new landscape, which has been called for from insolvency lawyers, insolvency practitioners for decades now, to seek and achieve a level of certainty as to how insolvencies should be run and operated, there have nevertheless been some fairly positive outcomes in terms of controls and predictability. One is the initiative introduced at the report stage in the Oireachtas, where personal insolvency practitioners will, for the first time, be registered with the new insolvency service in terms of their competency, in terms of their regulation, and in terms of how they operate and report both to the insolvency service and also to the courts, and also their duty of care to their clients and other parties who will be relying on the various arrangements that will emerge from their services. So these registered PIPs will have an obligation to provide advices both before and after the fact in terms of monitoring the arrangements. Another control and predictability that emerges from the new legislation is the statutory declaration as to assets. So the debtor now has to swear up, as it were, as to his or her assets and will have to stand over that. And there are sanctions and clawbacks and variations in the event that there is an incorrect statement made or that that the debtor's situation changes over the period of the arrangement. There are sanctions that come for false and misleading statements, and there are new arrangements then for fraudulent disposals of properties or preferences that are made up to 3 years in advance of the arrangement having been put in place. There are disclosure obligations for credit transactions over €650. And in any event, the ultimate control on all of this is that all of these arrangements, whether it's at the lower level below 20,000, and Joseph and others will talk us through the mechanics and operation of that, have to be disclosed to creditors. And the final approval of all of this remains with the court. A big issue, I think, and a big concern during the parliamentary debate at various stages was the position of the secured creditors. What would cause the secured creditors, the banks and the lenders, to engage at a fairly serious level with this new scheme, or will it be so unattractive as to cause them perhaps to want to stay outside the scheme? And a lot of this turns on the value and the enforceability of the security that they hold, and can they be crammed down, can they be squeezed out, and so on. As you know, and we'll talk about this further, 65% of those voting at their various creditors' meetings have to approve the scheme or the arrangement that is put to them, of which 50% in the larger of the two schemes must, on the personal insolvency arrangement, must be approved by the secured and 50% by the unsecured. So there are scenarios there, in fact there are a number of scenarios, where the first secured lender, both on the private residential properties and on other commercial properties owned by the debtor, could be crammed down, could be outvoted, depending on the circumstances, because judgment mortgagees or second or third charge holders will have an equal vote in the approval or refusal of approval on the scheme that's proposed by the personal insolvency practitioner acting in relation to it. So all of these are in play, and I'm sure all are being watched very closely by the lenders, the secured lenders in particular, about which more anon. And I know that Michael Aiden is going to show us some case examples of how this could play out. So, in conclusion, at least to these introductory comments, there will be very close scrutiny, I have no doubt, by lawyers, accountants, debtors, lenders, and all other interested parties, including the courts and the new insolvency service, of the proposed arrangements from the personal insolvency practitioner. There will be very close scrutiny, certainly by the lawyers and the lenders, of the declaration of assets and any transfers of assets that have been made, and any untoward contributions, for example, to pensions or to third-party liabilities that have been made on the run-in to the arrangement as proposed. In the settling-in period, certainly for the first 2 years, I anticipate, there will be a lot of activity around the courts until the new rules are cemented and put in place, and the insolvency service sets out the various arrangements. And there will be a lot of legal challenge around this. And certainly that was the case in the context of the examinerships when they first came into play back in 1990. And to some extent, this new regime is a rerun of the examinerships, except it's on the personal insolvency side. So the attendance at the creditors' meetings will be crucial. Who's attending, what they're proposing, what's being proposed, what they're supporting, the value of the security, the proxies, the authority of representatives of the various creditor classes to attend, and also the procedures to be followed at the creditors' meetings. So it's going to be a busy time. I think, on balance, this is a positive initiative, but it's not without pitfalls and challenges for us all.